My name is Kurt Royce. I am the CEO of EB5 Marketplace, and in coordination with Finalis, the broker-dealer firm that supervises my activities, we have developed a RIA compliance service that we will talk about today. So we'll talk about what is required, and we'll try to also provide you with actual ways to address the requirements. If anyone's not clear, RIA is the acronym that we use to describe the Reform and Integrity Act of 2022. Kathy and I are both on a securities roundtable, and I was looking at my notes as I was preparing for this webinar, and I came across about 20 pages of notes from the roundtable, and the title of it was the Integrity Act of 2015. So this has been going on for some time, folks, but I think it's finally here. And even though we don't have complete clarity on all of the items, and I think Robert has provided some excellent comments to USCIS on how perhaps some of the regulations can be interpreted. So what's the purpose of the Reform and Integrity Act? I would say that there are two things that jump out at me as the major factors here. One is protecting investors, and one is to adjust the investment incentives. We're going to focus on the protections that have been provided to investors. Before I move on, though, I want to explain what protecting investors means. It doesn't mean that the investment capital is any more safe than it would otherwise be. There are no safety precautions to protect investors from losing their money. There are also no protections to avoid not getting your immigration benefits. When we say protect investors, what we're talking mostly about is fraud. The integrity measures that we see in the bill require a great deal of transparency. And when you have transparency, disclosure of conflicts of interest, we can avoid a lot of the unfair dealings we've seen in the past. That's what I think the intention of today's conversation is going to be about. So how does USCIS do it? Well, what they're going to do is they're going to require regional centers to certify to the best of their knowledge after a due diligence investigation. It's an interesting line, right? To the best of my knowledge, gives you a lot of wiggle room. Hey, this is the best that I knew after a due diligence investigation. If you don't know something, well, then the due diligence investigation that was performed that you were relying on is going to be scrutinized. So before we get started, I also want to alert you now, remember, this is a presentation of our service. So the EB5 broker-dealer has developed a service to provide compliance for regional centers and the EB5 funds. We believe that you need 3 entities to properly supervise your offering. It can be done in-house, but I think there's also a lot of reasons to believe that you're probably better served to have somebody who's doing this on a regular basis. So you'll need a due diligence analyst, a compliance officer, and a fund administrator. And of those 3, EB5 broker-dealer is looking to provide services on the first 2. Bodies of law. These are the 3 areas that I think probably encapsulate the majority of what needs to be done from a compliance standpoint. You've got federal and state securities laws, you've got specific EB5 program requirements, and you've got federal labor laws. Of those 3, the federal labor laws is probably a bit ancillary to it, but I wanted to make sure it was on the slide. But mostly going to talk about securities laws, what you need to do to satisfy them, and the new program requirements. So securities law compliance. Kathy, you are a securities law expert, and you put together a policies and procedures content checklist, and you identified these 5 areas that people have to consider as they think about the compliance system that they're going to put in place. Of these 5, I've highlighted 3 of them that we'll talk about in depth today. But the Investment Company Act of 1940, I just want to make sure people are aware that if you have a very large offering, you will need to get with your securities attorney to ensure that you are exempt from the Investment Company Act. And the Investment Advisor Act, new commercial enterprise managers should also get with their securities attorney to ensure that they are exempt from needing to be an investment advisor. So Kathy, let's start with the Securities Act of 1933.
I want to mention, first of all, how I approach compliance, and specifically the concept of a compliance manual itself is borrowed from the broker-dealer and investment advisor world, both of those types of registered professionals have had to have written compliance procedures, manuals for many years. And so when they are examined by the Securities and Exchange Commission or by FINRA, in the case of broker-dealers, the first thing the SEC or FINRA asks them to present is, show us your compliance manual. So that you give them the compliance manual, and then they say, and now show me, how are you complying with your own compliance procedures? So in this manual, you're going to say, these are the ways that we show that each one of the offerings that we, the regional center, sponsor, meet the requirements of all of the federal securities laws. And as Kurt mentioned, there's 4 federal securities laws, and there's also state securities laws. So Securities Act of 1933, that is the act that says every offering of securities is required to be registered with the SEC unless it is exempt. And many people in the EB-5 world are already quite familiar with these requirements. Regulation S is an exemption for offerings to foreign investors. Regulation D is an exemption for private offerings to US-based investors. And lastly, the Securities Act of 1933 requires that the issuer provide full disclosure to investors regarding all of the facts and the risks involved in making an investment. So this is what we broadly call the anti-fraud provisions. In your manual and in your procedures for Regulation S, you want to make sure you have an appropriate legend, and you want to show in your manual that you have internal controls to confirm that your offerings are made in accordance with that exemption. Namely, that when you're using Reg S for your exemption, you have to make sure that you're not conducting your offering in the United States. You're not directing it to the US. But if you are directing some part of your offering to investors here in the US, then you have to show that for that part of your offering, you are complying with Regulation D. And for that compliance, you're going to need several things. One, you're going to need bad actor questionnaires from everyone involved, the officers, directors, promoters of the JCE and the NCE. You're going to need a Form D filing with the SEC. You're going to want to show that you have a method of showing where your offering is directed to accredited investors. You have a method of proving that either the investor has certified to you that they are an accredited investor, or if you're using a verification process, what process are you using to verify accredited investor status? And that is important if you are using general solicitation. I won't go into that in great detail. Many people have done that before, but generally speaking, if you're going to use general solicitation, meaning you have information about offerings on a website or you otherwise make the information public, you have to verify that your investors are accredited. All of that is going into your compliance manual, and that's what you have to certify. When you make that annual certification to USCIS, you have to certify, I did all of those things. Lastly, in your manual, you're going to want to describe the procedures that you use to assure that your offering documents do not contain material misstatements or omit material information. And some of the things you're going to want to put in there are, you do background checks, you do a site visit, you interview key management of the NCE and the JCE. When I say you, by the way, I'm speaking of you, the representative of the regional center, because it's the regional center who has to make all these certifications. Going back to my list of anti-fraud, you want to show that you review project budgets, capital structure, construction timelines, feasibility studies, intended use of EB-5 funds. There's a whole list of things that you, as the regional center, the one sponsoring every offering of an NCE, you're required to show that you're looking at all of these things so that you know the anti-fraud protections are there for your investors. And now I'll turn it over to Rupi to talk about what you do.
Sure. So we design our due diligence procedures specifically for every project But generally speaking, we always have to take a deep dive into the business model, as you mentioned, into the financial model. We have to review the assumptions, whether they're reasonable. We will do our own sensitivity analysis. We'll do our own market research. It's all with the goal to confirm whether the repayment timeline or the repayment strategy is reasonable, or to identify any risks that we see with those claims that are being made about the rate of return or when they're going to get paid back. Some of the other items generally are management background checks, as you mentioned. We'll run background checks on all individuals that are involved and the entities. We're looking for lien searches, bankruptcy searches, bad actor disqualifications, and pending litigation. We want to review management bios to make sure that they actually align with what we have found through our background searches, such as employment history or education. There may be news articles about the management or the project or local concerns about the project. That's a look at the management that's involved in the deal. I would say there's also, like you mentioned, qualitative analysis, right? Meetings with management can tell you a lot. I find the quality of information someone provides to us can tell us a lot about their level of sophistication or understanding or the lack of experience. Sometimes sloppiness and inconsistencies can raise red flags. So at a site visit, it's also, I find, very informative. It can shed a light on how the business is run, if there's an internal in-house accountant or other professionals, or have they retained other outside professionals to help them with the whole process. Other items, we always want to review our corporate governance documents, review that the companies are duly formed, that confirm ownership. You always want to review the operating agreements or shareholder agreements, make sure they're aligned. The terms that are offered in the PPM are aligned with the underlying documents. So those are some of the general procedures, but as I said, we always design them specifically for the project. If a project has an operating history, of course, then we do want to look at current financial statements to date and analyze those, or tax returns filed. Those are some of the ways we confirm and identify the risks.
Rupi, you've been doing due diligence on projects that my broker-dealer and my firm have been selling over the last 10 years. And I always find it very important and helpful that the disclosures that we see in the PPM, we don't know if that is a complete listing of all of the possible risks that are involved in the deal.
Right.
You know, maybe just one general question. How frequently do you think you find risks that weren't properly disclosed after you complete your due diligence?
More frequently than you would think. Background searches, sometimes things will come up that we think is material enough to be disclosed, or anything related to the way the financial model is designed. So we often find stuff that needs to be disclosed.
So I just wanted to let the audience know that if you do not disclose something, maybe you just missed it. Maybe you just didn't think it was pertinent. Do you remember the time, Rupi, when you said, I need to see a disclosure about the possibility of a hurricane in Puerto Rico? And you got pushed back. Hey, we haven't seen a hurricane since I don't remember the year. And of course, what you don't want to have happen is investors say, look at this. In hindsight, I'm looking at this document and they did not disclose risks that were reasonable to assume. So these are all aspects of the 33 Act. I think this is one of the most important aspects and probably the most time-consuming and costly things that we need to do to give our broker-dealer the comfort to allow us to sell an offering.
Kathy, as you know, you're relying on the information that's being given to you, right, to draft the PPM.
Mm-hmm.
So you may not have the complete picture when you're drafting the PPM as well.
Right, exactly. I'm relying on self-representations by representatives of the JCE to tell us what's really happening with the project. But coming back to this compliance manual concept, the idea is that you regional centers are now being asked to show what are you doing to do your own due diligence on every offering that you sponsor. So you have to show them, here's how we do it. And you have to have documentation of that. So you can show them that is exactly what we did. So that's how this compliance regime is likely going to work in practice.
Kurt, let me add, I've seen USCIS audits of regional centers that have taken place before this new act was passed. And most of what happened in those audits is USCIS officers would go through the regional center application and see all these representations about things that were going to be done and diligence that was going to be performed. And they would then ask, okay, what have you been doing to carry that out? It's exactly what Kathy is talking about. So you have every reason based on past experience to expect that's exactly what they'll be doing going forward.
Kathy, you compared the written supervisory procedures of a broker-dealer to the policies and procedures manual that we see being required here under the RIA compliance. I also see a similarity between the role that they're putting the regional center in is similar to the responsibilities that are typically dumped upon the broker-dealer.
Yes, that's correct. So that's what they've decided to do. There's been a lot of fraud in the EB-5 industry. So the regulators determined that the best way to address it is to make some licensed entity responsible for trying to mitigate the dangers of fraud to the greatest extent possible. In the securities world, that's broker-dealers. In the EB-5 world, they put that responsibility on regional centers. So there's a lot of parallels now between what a regional center has to do and what a broker-dealer does.
If I could just kind of expand on this, really interesting topic, and I don't know that a lot of people understand the way the investment community operates, but the SEC doesn't generally police investments. They outsource that to FINRA. Let's use the analogy of broker-dealers being the cops. So the cops are there to make sure that everything is done properly. That's their responsibility. They can be fined a great deal of money and lose their license if they don't properly supervise an offering. FINRA is kind of like the internal affairs department in a police station, right? They're going to look at the cops, the broker-dealers, and they're going to determine, are you doing your job properly? Now, in the regime of Reg S and what EB-5 has seen in the past, we didn't have broker-dealers involved in many cases. And so therefore, we didn't have police, nor did we have the people that were supervising the police, because the SEC is really not built for that. What we're seeing now is we're bringing all of these requirements to the fore, but the problem is that unfortunately, instead of letting the securities experts do it, we're going to ask now USCIS to supervise securities behaviors. And I think that is going to be a problem. But let's continue. So the Securities Exchange Act of 1934, sometimes referred to as the 34 Act. Persons involved in sale of securities are required to register with the SEC as a broker-dealer unless an exemption is available. Kathy, can you tell us a little bit about how the 34 Act plays into the requirements?
Yes. So there's three main issues that you have to address when you think about compliance with this provision of the 34 Act. Number one, if anybody who's receiving compensation in connection with a sale of securities in the United States, whether they live here or they're doing business here or they're soliciting people here, have got to be registered as a broker-dealer under the Securities Exchange Act of 1934, or they cannot be paid. It's illegal to pay someone. Now, the SEC does allow foreign persons who have no business in the US, don't have offices in the US, and don't solicit persons in the US. They allow those foreign persons to receive compensation in connection with a sale of securities to non-US persons. So you can pay those kind of non-registered people. The third thing that your compliance manual is going to need to address is, what about all of the officers, directors, and employees of the regional center, the NCE, and the JCE? USCIS has asked this question, we know, in the past. Well, are these people required to be registered broker-dealers? And the answer is no, not if they meet the requirements of what's called SEC Rule 3A4-1. And there's a bunch of conditions that apply to that exemption. So your compliance manual is going to say, our policy is that we're only going to pay these people. We're going to pay US broker-dealers for solicitation in the US, and we're only going to pay non-US persons for solicitations outside the US. And then you're going to show in your manual, how do you make those determinations that you're only paying those people? So you're going to have records of who you pay and how you determine that you're going to require representations from them, from the non-US people, for example, that they don't have business in the US. So this is how you're going to build your showing to provide evidence that you are meeting all the requirements of the 34 Act.
Thanks, Kathy. And then state securities laws. There's a couple of interesting things that are involved in state securities laws. I don't generally hear people talking about the requirement of meeting state securities laws. Kathy, can you talk a little bit about how you think the USCIS, what they're going to require in order to satisfy state securities laws?
Yes, because it is specifically referenced in the Reform and Integrity Act. One of the requirements is the regional center has to show they have met the requirements of state securities laws. So state securities laws, generally speaking, will mirror the federal requirements in some respects, but every state's law is different. So when we're looking at evidence of compliance with state registration, that refers to registration of the offering itself. A couple things you need to know is, number one, all state laws are preempted for every offering that is conducted in accordance with Regulation D. So if you comply with Reg D, you're not required to comply with state registration, but you are required to make any state notice filings that are required by the states in which you make the offering. So that means you're going to have to do state notice filings in order to show compliance with state law if you're using Reg D. For Reg S, just know that not every state has a Regulation S exemption. In fact, very few of them do, but there may be other exemptions. So the point here is you have to look at each state in which the offering is being conducted to make sure that you have some evidence that you're in compliance with any exemption from registration. And lastly, I'll mention that every state has its own investment advisor rules, and you have to show that you've looked at those and made sure that the manager of the NCE is in compliance with any exemption that applies under the state law.
Robert, when I look at the policies and procedures manual, it looks to me you need to identify what needs to be done, how it will be done, and then how to show that it's been done. Could you give us a little bit of flavor to what we're thinking here?
The law requires policies and procedures, whatever that means. You can cram it all together into one manual. You can have different policy and procedures documents. Regional centers are going to have all kinds of arrays of documents that need to all say essentially the same things. Much of it is parroting the requirements that are in the RIA. But I think that the expectation of the government and whoever it was, probably the SEC, who was whispering in the ear of the legislators to get them to put these requirements in there, is they expect these policies and procedures to have a kind of a practical bite to them and not just be a recitation of the requirements of the law. They need to give a flavor that this will happen and how will it happen. Nobody's looking for a grade of A from USCIS. They're just looking to get by, I guess. They want to not be held up, get a request for evidence, get a denial of their regional center, and get extra hassle when they get audited, and have their investors have extra hassle when they're being adjudicated. So there is reason to try to do a good job and be kind of comprehensive and provide a sense that there really is a process in place that will ensure that these requirements are met. I remember being in charge of a federal agency that had 15,000 people employed and a $2 billion budget. And I remember saying at the time, I can put out all kinds of policies and descriptions of procedures that I want everybody to follow, but those things can just sit there and nobody pays attention to them and nobody does them. I mean, there has to be accountability. There has to be a follow-up to make sure that people are doing what they're supposed to be doing. And I would say that that reality is probably your best aspect of a sales pitch. I mean, that is the most compelling argument in my mind for having somebody in a role like yours that makes sure that people are doing what they're supposed to be doing, and that there are documents to prove it, so that when the auditor comes in, it'll all be clear. This has been done, this has been done, check here, check there, this supporting document is in the file that shows that happened, and so forth. There's general stuff that a regional center needs to be doing, but most of what a regional center needs to be doing is scouring each offering and project as it gets going. And the focal point for that scouring is the filing of the I-956F, the project application that the regional center signs, certifying that after diligence, everybody involved is going to be following the rules and the laws, and they're going to keep doing that. So I think in the context of leading up to the signature by the regional center on that form, there needs to be a very systematic collection of information from the NCE, the new commercial enterprise that's organizing the offering, and the project company that typically through the NCE, that will ensure that it's set up to comply with all the rules. So Kathy walked through a whole bunch of securities rules and exemptions that are needed in order not to do things that are nearly impossible to have to do. That needs to include, okay, which exemption are you using for that? Which of these exemptions are you using? What notice filing have you made? What else is going to happen? Just practical stuff, making them confirm which angle they're pursuing to meet the requirements and meet the exemptions from the requirements that they need. And that's just kind of the beginning. But on all these things, how are you dealing with promoters? What are you doing this, that, the other? And so it's very practical, I think, in an iteration between the regional center and the NCE.
It is very practical. I mean, we're going to push back on answers that we don't like. It might be more difficult for a regional center that's maybe less certain as to what the NCE should be providing to know how hard to push back on some of these things. Because I've heard people claim that no, they're certain that this is satisfactory.
Well, look, I've done deals where you guys are involved in the role you're talking about, and we do good work in putting deals together, but you guys have asked some very good questions. A couple of times it made us go back, scratch our head and think we might not have articulated that as much as we need to, or we maybe need to include this, that, and the other. So it's a healthy exercise, and having knowledgeable and experienced people in the room who've been through it before and are paying attention and know what really is required, poking on you a little bit is always a good exercise.
Yeah, I appreciate that. You think about it, the landscape is structured so that someone without a vested interest is going to look at the offering. A securities attorney's job is to look after their client. And so you want to have that third party come in and look at it with a disinterest and say, you need to disclose this more articulately, or you need to put this in a more prominent spot. So there are aspects that even disclosures don't always cover. They need to be presented in an appropriate way.
Well, and keeping records of everything as well. That's a very important piece that people don't naturally do, in my experience.
I just want to say that with the broker dealer and the regional center, now the interests are aligned, right? So as a broker dealer, you have to do sufficient due diligence to satisfy FINRA. And therefore, your interests are really aligned with what the regional center needs to accomplish as well.
One other point I would like to add is that where Robert says, well, you need to make sure you retain your records of what you actually did, put the list of what records you're going to maintain into your manual so that the person who's doing it knows what has to be in there. You want everything to match. The manual says, oh, we're going to do this, so we do that. The manual says we're going to keep these records. So those are the records you want to make sure you have, and put someone in charge of checking off to make sure that you have all those records.
Before you file the 956F, I would say.
Yes.
Yeah, and then there's stuff beyond that that you need to do. So back to the promoters.
I've listed 5 lines here. Promoters need to register. NCE must conduct due diligence on the promoters, which includes overseas. Maybe we should just touch on that one, Robert. That's a difficult one to get our head around. You need to do some due diligence on these promoters. And the question of how thorough the things you must do. You need to have a written agreement with all promoters. And this is an important document because it's going to outline to the promoters what they can and can't do. Is the industry, do you think, prepared for these new requirements?
Well, you know, I hear things that are worse than what I've seen so far. What I hear is that there are some regional centers who are cleverly devising schemes to have some kind of Uber broker in one place maybe even outside the US, who has an agreement with the NCE that's making any offering, and that there won't be any written agreements otherwise filed and no other promoter filings made other than that. And I think the people who are conceiving that scheme may think for the moment that they're clever, but in the end, that's going to turn out to be a failure. And that's going to be a problem for them and everybody who invests with them. Because USCIS, there's several ways this is all going to come together. One, every promoter is supposed to be filing this registration. And in the registration, they say who they have agreements with, right? And every investment needs to include a written disclosure to the investor of everybody who's getting paid out of the deal, right? And that clearly needs to include the people who are working right there with the investor. And anybody who wants to argue that you don't need to disclose the compensation that the person who's standing there talking the investor into the investment and getting their signature on the documents is living in some kind of parallel universe, because that's the most important conflict of interest of all. And any scheme that's designed to prevent the disclosure to the investor of that person's, that agency's compensation is just trying to fight against the spirit and ultimately the enforcement of the rules. So assuming that that disclosure is made, then that has to be filed with the I-526. So USCIS will see the disclosure that's made that discloses who got what out of the sale of the thing. What do you think they're going to do? They're going to go see that each one of those promoters has registered. And if they're not registered, now we got a problem. It's a whose problem and how that's all going to shake out. Is it going to result in a denial of a 526? Is it going to result in enforcement and sanctions, maybe debarment, maybe termination of regional centers, NCEs who aren't following the requirements, that ultimately can then backfire to investors and cause them to be denied or revoked? I mean, it's a bad cycle. It's all designed to kind of fit together and result in a little ecosystem where you can't get around the requirements. And I don't think that some people have thought that all the way through. I believe in the end, it's going to be necessary to disclose all those compensations, and all these people up and down the chain are going to need to be registered as promoters. And I don't want my clients who do that to be competitively disadvantaged with others who are not following those rules. And I can tell you that you've mentioned I've made comments to USCIS about the forms. I am bringing this issue up poignantly to USCIS, so they cannot ignore it. They cannot not realize that it's there. And I believe they will follow up on it.
Moving on to fund administration. Robert, I'll have you walk us through this. By the way, people have asked us if we do fund administration, and because we're a broker dealer, and as a broker dealer, you can do fund administration. Well, let me tell you, this is not something to take lightly. This is complicated. It involves money. It involves liability. And so I would suggest that when you select a fund administrator, it does help to pick somebody who understands this industry, who's very clear on it, and again, has procedures in place that they're using over and over again. So with that caveat, Robert, can you walk us through what are the requirements on fund administration?
Yeah, so the main requirement is that money that comes into an NCE that is invested by the EB5 investor into the new commercial enterprise must be placed into what the law calls a separate account. The capital needs to be placed in a separate account and cannot be mixed up with other money, so that there can be complete transparency and accounting that shows the flow in, the flow out of the EB5 capital, and it can't be mixed up with anything else. Your slide says that an escrow requires an insured U.S. bank. It's actually not accurate. It's more general than that. The separate account of the NCE must be with an insured U.S. bank. The separate account can also be, for a time, an escrow. I think there'll be far, far less use of escrow than there ever was, because the separate account that's required to have this fund administration is in effect an escrow account. The fund administrator is in effect the escrow agent who's making sure that the money is being dispersed appropriately according to the documents that are in the deal. That doesn't mean you can't also have escrow, but to me, it seems like a pretty superfluous extra layer of effort and cost. But there has to be a separate account at the level of the NCE. And if the project company, the job creating enterprise or entity, is affiliated with the new commercial enterprise or the regional center, then there has to be a separate account also at the level of the JCE that only EB5 capital comes into. And it doesn't come out until the fund administrator has confirmed in writing that the conditions are appropriate under all the documents of the deal and the development of the project to be released for expenditure in the project. I believe that the people writing this were contemplating the kind of process that anybody who's ever gotten a commercial loan understands, where the bank doesn't just give you money at the beginning and say, here's your loan, go build something. They say, you tell us when you need some money for this thing and tell us exactly what it's for and give us supporting evidence of that. And then we'll give you a draw to cover that and no more. And when you need some more money, come back and let us know and we'll give you some more after you prove all that. And then when it's all done, we'll confirm that all of it was correct and spent properly, and we'll do some audits following up on all that to make sure you spent it only on what you were supposed to. Because banks have kind of learned over time that when people get their hands on a bunch of money, they sometimes lose their head. And I can tell you from my experience in EB5, that phenomenon is very true. And so this is designed to counteract that and require the discipline of the involvement of dispassionate, unconnected third parties whose job it is to make sure that things are done the way that they were represented, that they were going to be done. The fund administrator can be a lawyer, it could be an accountant, it could be a company that makes a business of being a fund administrator, but they can't be your lawyer. It can't be the main lawyer of the NCE or the regional center or the JCE or their normal accountant. It has to be somebody whose only role with them is doing this, right? So they're not beholden to those folks. It keeps them independent. This is not a new concept at all. And there were some parties who were doing this kind of thing before the RIA, and that's great. Now that everybody has to do it. And then there has to be periodic information. Some of that information would be the investors can request from the fund administrator, I want to see documents about how this money's been handled. And they are entitled to get that within like 30 days. And then documents have to be kept for a long time just to confirm what was done.
Rupi, do you have any thoughts?
One question would be, so once the money is released from the NCE to the JCE, it can go into the JCE's general operating account, right? There's no separate account required for the JCE?
There is if it's an affiliated JCE. So if anybody who's associated with the NCE or the regional center is involved with the JCE, then it's an affiliated JCE and there has to be a separate account at that level. To me, it's a little fuzzy, unclear how it works when there are two separate accounts at two levels, because ostensibly no money gets released from the top level until it's ready to be spent at the JCE. So you would think in a way, it's just going to be a double flow right off the bat. I mean, the minute it gets released from the NCE, it's appropriate to release it from the JCE separate account as well. And I'm sure there are going to be people who go ahead and release from the NCE separate account into the JCE separate account earlier than maybe prudence might suggest, but they better not let money come out of the JCE separate account until it's ready to be spent and not just hand them money.
And what if you're repaying bridge financing, let's say to an owner, right, of the JCE?
Well, if that's part of the business plan, then I think it just needs to be documented. That's what it's for.
Okay.
And documentation about the bridge financing, how it was injected, how it's been spent. And the fund administrator can say, yeah, okay, the business plan included that it was going to be, the money was going to be spent on that. And there's proof that the money that's being replaced was used properly on the job creating project, just as EB5 money would have been needed to be spent that way if it had been available at the time that those expenditures arose. And then the fund administrator can authorize that disbursement.
Record retention, obviously, we're not getting into a lot of details here, but Robert, do you want to give us just a off the top of your head, some of the records that need to be available to USCIS?
A lot of documents that were behind the preparation of plans and PPM and agreements at the
Forwarding
beginning.
documents, yeah.
But then also, all kinds of documents about what happened afterward in terms of actually executing the business plan and the flow of money. So the most important documents for retention, in my mind, are all those draw requests and the payment of money that satisfied those, because those end up becoming essentially the documents for the I-829, but they also need to be kept by the parties involved. But there are a bunch more types of documents, but it's really about the flow of the money. It's mainly about just showing how the project progressed and how the money flowed to show that it was done properly and nothing was diverted. Right.
Rupi, when you do due diligence, I know that you have to keep record available for an FINRA inspection. What kind of records do you need to keep filed away and immediately available for a FINRA or SEC inspection?
Well, when we do the due diligence, we do have to turn over the whole file to broker-dealer, right? So they can keep it on record for the FINRA review. It's essentially the whole offering package, any material agreement that we have reviewed. So any of the analysis that we've done on the financial model. So all that file that we turn over to the broker-dealer.
Kurt, there's one other thing that needs to be kept, and this is in line with what I said, but I think it's important and specific. There's a specific requirement to keep documents showing what payments were made to all the promoters, essentially. So there was a written disclosure to the investor on the front end, what people were going to get or were in the process of getting, but then the regional center needs to keep records of what they actually got and like documents showing what the payments were and to whom.
Yep, I'll just add to that. What I find as one of the most challenging things as selling agent of an offering are getting compliance approval on marketing materials. Things change. And so you get approval on marketing material, but then something changes and now you need to go back and make edits to it. So marketing materials can be very complicated and they can take time. So that does slow things down a bit. And then of course, if they get modified, you want to make sure that you have version control of those documents. So we have built a portal, an online portal, where the issuer loads up their marketing materials. Our compliance officer reviews those, approves or provides advice on how to make the marketing materials more accurate, less promissory, less exaggerated, whatever the issue happens to be. And then once it is approved, it moves into a location on the portal where it's available to agents and to investors. Labor law compliance. I think we're at the end of this presentation. Robert, can you give us a sense of what are we looking for here?
I don't know. I don't think anybody really knows. In my preparation of something to satisfy this requirement, I looked and found some documents, some kind of general government documents about labor law compliance that threw in as with kind of some checklists of things that people need to be doing. The law is super unclear. I mean, about who this really relates to. Technically, you could read it to say that it applies to the regional center, which is kind of nonsensical in the sense that regional centers hardly employ anybody. And I think that this really arose out of some union complaints about that Catherine knows all too well, about some particular hotels arguably violating union laws and trying to oppress them and whatever, which were pretty well unfounded. But I think ultimately it's going to be interpreted to be meant to relate to the JCEs. But for now, on the surface, it says the regional center. I think it's wise for the regional center to just have the NCE and the JCE just report that they have Labor and Employment Law Council, and who are they, and that they're committed to complying with federal and state labor laws. But I don't think it, as a practical matter, it's going to go beyond that until USCIS starts doing some audits and requiring more. They're publishing something that puts meat on the bones of this requirement in the law.